Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me right here on this station every Sunday from 8 to 9 a.m., where I bring you, the landowner, the valuable information that you need regarding natural gas development here in Pennsylvania. And in case anyone has forgotten, I represent landowners and only landowners in all oil and gas related matters. I have not, do not, and will not represent oil and gas companies. I represent Pennsylvania landowners and oil and gas right owners for such items as oil and gas lease negotiations, reviews, royalty issues, consultations, pipeline agreements. I'm pretty excited today because today is going to be a pipeline day, so stay tuned. I'm doing more and more with estate planning, royalty issues, unitization issues, surface use agreements, real estate transactions in the Marcellus shale and natural gas areas across Pennsylvania, buying and selling oil and gas rights. If you're considering selling your oil and gas rights, I'm telling you, commercial alert, call the office. Call the office, do a review and consultation, decide if it is right for you. Decide if it is right for you. It's always easy to look at money. It's not always as apparent to see the hidden below the surface issues that may come up in the future, and not just you getting a big fat check and everything being wonderful as it is typically represented to you by the individual who is trying to broker a sale and broker a transaction where they enter into an agreement with you, you agree, and then they go out and try to shop to a buyer who will buy the gas rights, and they act as the middleman. Unfortunately, this is occurring all the time. It's happening all the time where the landman purports to be out there to buy your oil and gas rights on behalf of a specific company. Well, check this out, because many times this person who's seeking to buy the gas rights for this particular company is actually serving solely as a broker. They've created their own LLC or limited liability company. They get you to sign a document saying that you're willing to sell your oil and gas rights for a certain amount of money. Then that broker goes out and shops to companies, hedge funds, investment groups, whatever we want to call them, who would be interested in actually buying the rights. So the individual sitting at your table in many cases is simply a broker looking to be a middleman to get you to sign a piece of paper and then go shop the rights based on that piece of paper that you sign. Meaning, you enter into a contract with this broker to sell your gas rights for a certain amount of money. And let's say, we'll use a simple number, $5,000 per acre. That broker then has no intention with their company to buy your oil and gas rights. They've only entered into an option agreement saying that, hey, we have 3 months, 6 months, and they'll try to build in as many extensions as possible to buy your oil and gas rights. Then they go out and they shop them around. And I just had a case the other day where my client was given much higher than what was originally offered, $10,000 as an option payment, and then he in exchange gave a certain amount of months in which to conclude the deal. Well, we just got a call. My client just got a call and said, hey, can we extend this some more months because the broker can't find a buyer. So what looked all fantastic at the beginning now, or at least in this person's mind, now doesn't look so good. Now, thankfully, we did a very strong landowner-friendly option agreement that allows the client landowner just simply walk away. But these documents to purchase your oil and gas rights tend to be written in a way that creates a lot of loopholes, or it gives the company or the entity the ability to extend these agreements over and over and over, or for a longer period of time than what you may think. So what happens then is that broker middleman, in my example, then tries to buy themselves or finagles to give themselves more time to try to find somebody or a company or entity to purchase the gas rights. At which time, think about it. If you enter into a contract with them to buy your gas rights at, say, $5,000 an acre, well, they're going to go out and try to sell it higher. If they can sell those rights, once they get your name on paper, they say, hey, company, I will transfer you this document. I will transfer you this document, and then you can conclude the transaction with the landowner. You will then buy the rights from the landowner. You'll take my place, and I will walk away. And, oh, by the way, since you've agreed to pay $6,000 an acre, I have a contract to purchase these rights at $5,000 an acre, and there's 100 acres involved. I get the difference as a broker, and so you buy the rights at $6,000 an acre, so that's $600,000. I have a contract for the rights at $500,000, so me as a broker, in my hypothetical example here, just made $100,000 by acting as a middleman, going out and getting a landowner's signature to sell oil and gas rights to me, which I then assign to a company willing to pay more, and I get the difference. Pretty darn good deal. Landowners, maybe you want to get out there and get in this racket, because those types of transactions, you may say, hey, that's good for me. Or you may say, boy, that doesn't smell good to me. I don't like the way that sounds. I don't like the way it feels. I don't like the way it smells. And I don't want somebody else making significant money off of my oil and gas rights. So if you want to have some fun, here's what you do. You say, okay, landman who's out here to purchase my oil and gas rights, or have me enter into a contract, an option agreement to sell them to this landman or their company or the company they work for. How about we do this? Let's add a sentence in here that says that you, who I'm signing this contract with, you company, cannot assign, sell, or transfer the rights in this agreement or this agreement to any other party or entity. Well, you're going to find, and I'll take a little friendly wager, they're not going to agree to that. Despite they may sit there, and I hear this all the time, well, we're not one of those companies that flip oil and gas rights. We're not one of those companies that flip oil and gas rights. Well, that's great. We like that. So, okay, let's put that in the agreement. Well. Listen, nothing counts unless it's written in the agreement. If you don't believe me, go and read these agreements that say things like no oral, verbal statements outside of the terms of this agreement apply in any fashion. You've not relied on any oral or verbal statements made by any party. They may say the landman has no ability or representative to make any oral, verbal statements that can bind us as a company. That language is in a ton of these agreements. Aside from the fact that when you have a contract dispute, the rule is you look at what they call the four corners of the document. And what the landman told you, we're not going to assign this, or we're not going to put anything above ground, we're only going to put one pipeline. If that's not in the agreement, it doesn't matter. So what is the moral of this easy story? Put it in the agreement. And if they don't want to put it in the agreement, flags should raise. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. You can join me right here every Sunday, 8 to 9 a.m. on this station, where I bring you the information that you need regarding natural gas development. All right, so I got, talking about buying, selling gas rights, it's just, this is something that drives me crazy. And we have landowner frustration out there in the communities. Frustration because most people who signed oil and gas leases, especially in 2008 and beyond, thought by now they would have a lot of money. And in many cases, they thought they'd be millionaires, and in some cases, millionaires 10 times over. For the most part, that has not happened. So we have a lot of individuals, a lot of landowners who are very frustrated, and understandably so. So what happens is you take this environment where you have a frustrated landowner and you say, okay, hey, I talk about opportunities all the time. This is an opportunity for the company, and for new companies to come in and say, hey, these landowners are really frustrated. Price of gas is really low. This is a prime time to strike, to go out to buy, to forever and permanently buy oil and gas rights from these individuals who are very frustrated. So let's go out there and let's offer them a low ball number. In most cases, let's offer them a low ball number, and we'll offer to buy these oil and gas rights. And because of the frustration out there, and because people think, I don't know if this is ever going to happen, what's going on, who knows, take the money and run, well, people are signing. And again, there are multiple things. One is, in my opinion, rarely do I ever like to see a landowner sell their oil and gas rights. Let me repeat that. Let me make it clear, because I know I got guys out there who listen all the time who are involved in the market of selling oil and gas rights. I want to make this very clear so there's no misunderstanding. As a general rule, I am very much against landowners selling their permanently selling their oil and gas rights. Generally against it. However, there are times where I understand it. I've never been involved in one of these transactions where I walk away saying, oh, this was great, I'm so happy for the landowner. It's usually bittersweet because the landowner may be pleased what they're doing, but it's a bit bitter because there probably is going to be more royalty income in the future, so you just hate to see someone miss out on potentially a lot more money in the future. But again, we need to look at every single situation. If you're in a situation where you're older, you want to go to Florida, you're getting out of town, you want to go to Arizona, California, who knows, maybe you want to go to Canada or Alaska. And you say, hey, I can sell these gas rights. Maybe I can make $500,000. I retire, I'm out of here, and that's what I want to do, and I'm ready to go somewhere else where it's been my dream to go to. Well, then that can make sense. You don't have heirs, you don't have kids, grandkids, whatever. Well, that may make some sense. And I could conjure up other areas or other scenarios or examples where it can make sense. But as a general rule, I really don't like it. And that's why I say to people, if you're seriously considering selling your oil and gas rights, sorry about the commercial, but I'm telling you, I think about this stuff all the time, probably more than most people. And I have conversations with people and landowners and clients about these transactions. I've been involved in many of these transactions. I've reviewed the letters. I've reviewed sales agreements. I've reviewed deeds. And I can tell you this, do yourself a favor if you're seriously considering selling the gas rights, your gas rights, schedule a conference call, come into the office, sit down, we'll do a review and consultation and talk about why you're doing it. Think about all the different reasons, positives and negatives, and then ultimately you may decide, hey, I still want to do this. I think this is in my best interest. That's your decision. However, then let's look at the documents, the sales agreement, the purchase agreement, and let's identify all of the and typically significant loopholes that are in that document. And if you're going to proceed, you need to make sure we clean it up. Just like my example earlier, my client, we did it. He said he wanted to sell. I didn't really like it, but we said, hey, let's do this the best we can then. We negotiated more money. We obtained a significantly better option agreement, which because of what we've done, now that the broker landman can't sell or sign this lease because he can't get a party in time, another company, well, now my client can walk away, keep his $10,000 option payment, way more than what attorney fees were, and say, okay, hey, nothing lost here and actually something gained. We got to make sure if you're going to do it, you do it the right way. Okay, we're up against the first break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to get into some pipeline issues in the next segment. Stay tuned once again for this very important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump right into this because I want to talk pipelines. And it may sound funny, but I love talking pipelines. I love it. Probably my favorite thing to work on are pipeline agreements, pipeline negotiations. And I'll tell you honestly, I guess because you hear me say this, I haven't been involved. And I'm so sorry. I'm so sorry I keep saying it, but I'm telling you, this should, to me, and somebody who does this every day, this should mean something. This should give you an idea of the information and experience that is out there, and how when you look at one agreement in a vacuum, or you look at an agreement with your neighbors, and you look at a few agreements, I'm telling you, that is way too small of a sample size. There is so much information out there and experience out there that we need to seize and take advantage of. So I talk about this often because I think it's really darn important. I have negotiated, consulted, worked on, at this point, agreements, pipeline right-of-way agreements with over 60 different entities in Pennsylvania. 60 different entities in Pennsylvania, from Wayne County, Pennsylvania, to Greene County, Pennsylvania. And Wayne County being the most northeastern county in the state, and Greene being the most southwestern county in the state. I've done hundreds and hundreds of pipeline right-of-way agreements. I know what companies will do, what they won't do. Some things that companies may do. I can sit there and say, okay, I'll say 50 companies. Well, 40 will agree and 10 won't. So do you want to push for this or you don't want to push for this? Or, hey, this is something just nobody ever agrees to. So if we continue to push, I think at that point, you're going to be spending money and time that's not warranted because nobody agrees to this. So what's reasonable? It's not, hey, look, we're not saying that you're going to get, okay, well, we're going to give you $1,000 a foot for pipeline. You're going to get paid every year, a rental payment. You're going to pay you for every unit of gas that goes through these pipelines. You're not going to get that. You're not going to get that. But what can you get? I'm going to tell you this. When you're asking yourself that question, what can I get? You better not be relying on the person who works for the oil and gas company to tell you what you can get. You need to get your own independent assistance. Whether it's me or somebody else, please get knowledgeable, experienced advice, or knowledgeable person who provides you experienced advice to assist you and to explain the agreement and explain what's strong, what's bad, what you can get, how you can do better. And do not rely on the gas or pipeline, in this case, company landman. Why, everybody? Because they work for the company, not you, the land owner. You're in a negotiation. Do not rely on the person who's negotiating against you. I mean, it seems nuts, but honestly, it occurs all the time. I'll keep saying it. I know some people are listening to it. I know a lot of people don't even know the existence of the radio show, but I'll tell you, we got to get it out there. We have to do better because overall knowledge and education benefits everybody. Everybody. You hear me say, look, if everyone stopped signing garbage pipeline agreements at garbage compensation rates, what will happen? What will happen? I'll tell you what will happen. Agreement offers will be better across the board for everybody. More money will be offered, better language and terms will be offered in the agreements. But as long as people sign bad agreements on a regular basis, you're not going to see improvements in those agreements. Why would a company offer more money when people are signing at the current offer, whether it be, I hate to even say these words / numbers, $5, $7, $16. I mean, I'm shaking my head here. Like, people are signing at these low levels, and they're signing 5-year option agreements. They're signing agreements that give the companies 5 years to decide whether they even want to use these agreements. So the company knows, hey, look, we have no intention of doing anything anytime soon. So let's do this. Let's send out land guys with low ball numbers, long option agreements. Well, we're simultaneously, Shell, Sweppy, simultaneously out there getting 10-year lease agreements at the lowest minimum royalty allowed under the laws of Pennsylvania. Lowest minimum royalty allowed in Pennsylvania, 12.5% with full deductions for 10 years, a 10-year commitment, which can be much longer than that. 10 years, and then simultaneously, well, we're offering the worst offers out there, in my opinion, at the lowest possible royalty with full deductions. While we're doing that, let's simultaneously offer $5, $7 a foot for pipelines with 5-year options. Let's do that. Why would we do that? Well, people are signing. Let's keep doing it. Well, heck yeah. Let's keep doing it. So people keep signing, and you'll keep getting 10-year offers at 12.5% at the lowest possible royalty rate. You'll keep getting $5 per foot for pipelines and a terrible language in your agreement. Terrible language, and you'll keep signing them, and we'll keep getting them. And then we'll tell your neighbors, oh, well, Joe signed, this guy signed, we want to give you what we gave your neighbor because, that's only fair, just like all those guys in all these other counties that signed for $10, $25, $50 an acre, and their neighbors got $5,000, $6,000, or $1,500 an acre. You saw how the companies were fair there and wanted to go back and give everyone that same, you signed at $50 an acre, your neighbor signed at $5,000. We want to be fair, so let's go back and give you the difference. Let me tell you this, guys, never happened. So when you sign a $5 agreement, you sign a $5 per foot agreement, $5 per foot. You sign that. And then you look at what happens in the next, whenever 5 years comes, and if they use the agreement or don't, they have 5 years to decide. So let's fast forward 5 years, and let's take a little wager what people are going to be signing pipeline agreements for in 5 years. We don't have to go that far. Let's go 2 years, 3 years, 4 years. Same thing happened in Susquehanna County. Same thing happened in Bradford County. People signed these initial offers, the low-hanging fruit, people who signed bad deals. And now we have a worse situation, a worse climate for the landowner because landowners are frustrated, understandably so. How do we take advantage of frustrated landowners from a company perspective? How do we do that? Well, let's go out there and sell them cheap pipelines. Let's go out there and buy their gas rights real cheap. Well, how do we take advantage of them selling cheap pipelines? Well, here's how you do it. You go out there and you say, hey, look, it's been really tough. Market's really bad. We don't have any money. We need to get pipelines in the ground to get you royalties. We really want to get you royalties. We want to ramp this thing up. Here's some documents. We're going to get these in the ground right away. We're going to get them in this year. Next year, it's going to be operational. Kumbaya. Everything is going to be fantastic. Landman, why does this say it's a 5-year option? You have 5 years to decide. Well, we're going to put it in next year. They're planning on putting it in next year. That's just a form agreement. Okay, great. Well, how about this? Since they're going to put it in next year, I'll be a reasonable person. I don't even need a year option in order for you to decide whether to do it. Let's do it this way. I'll give you 2 years. Since it's going to be in the ground next year, I'll give you 2 years to decide. That seems pretty reasonable. We can't do that. Why? Because next year, I'll bet you, in almost all of these cases, you're not going to see a pipeline in the ground. You're not. Now, lawyer disclaimer time, radio disclaimer time. This is not specific advice for any particular person. It's not specific advice for any listener. But what it is information to get you thinking. Do I want to sign? All right, I got to calm down. Do I want to sign a pipeline agreement for $5 a foot, $7 a foot, $15, $16 a foot? Do I want to sign that today when I don't have a gas lease? I have a gas lease that expires in 10 years, and you want to have a 5-year option agreement? Do I want to do that today? Well, you'd better be asking yourself the right questions. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So again, I get into these pipelines, it gets me fired up because it really, truly does. We have to stop signing bad agreements. We have to not let frustration dictate your decisions. Companies know how to use high gas price markets. So here, let me explain. Price of gas, really high, $10 per MCF. Hey, landowner, go type in this information in a royalty calculator. Go look and see. And now here's some numbers that we might produce in volumes. So go see how rich you're going to be. Oh, and here's the agreement. Here's the lease. You sign, you're going to be really, really rich. Well, okay, high gas price market, I'm going to be really rich. Let me hurry up and sign. Company says, look, run these numbers at you getting 12.5, say 15. Look, only SWEPI gives 12.5% across the board. They're the only ones. They're the only ones that I regularly see. Only ones, and I see all across Pennsylvania. It's killing me, guys. So okay. You see these high gas prices. They say, oh, I can't use 12.5%. I'm going to try to stop uttering that number. I hate that number. I got to stop. So, okay, high gas price. Company says, hey, look, run these royalty calculators at 15%. You don't hear these royalty calculator arguments happening so much today, but they still do. So let's run these at 15%. Price of gas, $6, $7, $8, $9, $10. You're going to be rich. Here, hurry up and sign so we can make you rich. Rich, rich, rich. Here's the pen. Here's the paper. Here's how you get rich. Pen plus paper equals rich. Now, low gas price market. Gas down to $1 a unit. Company says, hey, we got no money. We can't pay you anything. When they had all the money, they weren't saying, oh, we're so rich here, let's give you a ton of cash. They're saying, hey, you're going to be rich, so here, hurry up and sign this. So now gas prices are low. Company says, hey, look, we want to make you rich, so we need to get these pipelines in, but we don't have money. Here, sign these agreements, which are very bad, in my opinion, very bad agreements for landowners, especially at $5, $7, $15, $16 a foot. 5 and 7 is a joke. I've just done a bunch of FERC interstate pipelines that have eminent domain authority, or will. It's anticipated that they will, and they're all way above, considerably above, well, maybe be conservative. They're all above $50 a foot. All of them. So $5 a foot for a pipeline, in many cases that the company has no rights whatsoever to put into the ground. Then on top of that, a 5-year option to decide whether they're going to use it, or maybe it's going to be a 3-year option, and they're only going to give you $500 up front, $600 up front. To me, that's a joke of an agreement. Again, not specific advice. Everyone should just listen and consider these things. But I'm telling you, it's just the reality of the situation, in my opinion, that people are signing horrible agreements, not understanding. They're frustrated, which is extremely understandable. Companies understand the psychology of the landowner and how to take advantage of it. We have to stop it. Remember, think about these things, not specific advice. Think about them, because we're signing bad agreements, and that's what we need to stop doing. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, I'm here every Sunday from 8 to 9 a.m. on this station to bring you the information that you need regarding natural gas development. And I want to jump back into the pipelines here. You know, I have these pipeline agreements. I'm telling you, I'm sitting here, I got like 5 or 6 pipeline agreements I'd love to talk about. And I know I'm never going to have the time, but I want to get into this broad brush, big picture stuff. And especially, look, it's everywhere, but Tioga County, that area right now, I know I've got several calls over the last few weeks from landowners who are being approached again, in a lot of cases, for pipeline right-of-way agreements. And in particular, these cases and these ones are SWEPI. And what we're seeing is we're seeing, one of them I think is offered $5, one is offered $7 a foot, and they're bad agreements. Really bad. I always say money's easy. Money, in this case, in my opinion, not specific advice, is very bad and too low, in my opinion. I believe that gas companies and pipeline companies are taking advantage, in my opinion, of landowner frustration. And they're using the frustration as a tool to get landowners to sign bad agreements. We need to identify this. We need to identify the fact that, hey, I'm frustrated. Let me look at myself. I'm frustrated. I'm approached with this agreement. Let me take a step back and really get this. Let me look at this big picture. I have a lease that's not, or we'll say maybe it's going to terminate in 10 years. Maybe it's terminating this year, and we know the company isn't going to develop and it's going to terminate. Whatever, maybe it terminates in 4 or 5 years. But I'm offered a pipeline right-of-way agreement that's a 5-year commitment. A 5-year commitment where the company wants to give me virtually no money of any significance up front. Then they have 5 years to decide if they're going to use this agreement. And then if they do use the agreement, I am going to be in the incredible, fortunate position of getting $5 or $7 per foot of pipeline that they put on my property. And yeah, I'm aware of people in Susquehanna County routinely signing for over $30 plus a foot. I'm aware in other areas of the state people are signing for a much higher price per foot. But hey, look, I think this is an opportune time for me to jump in, make a commitment at $5 a foot for the next, or 7, let's just be nice, let's say 15, 16, for the next 5 years. Why are you going to do it? Again, you got to look at it in your specific case, but you really got to ask yourself, why am I going to do this at this time? If the company tells me they don't have money, and they also tell me that they expect natural gas prices to rebound moving forward, why should I jump on an agreement offered by a company who tells me they don't have the money now to offer more money, but they do anticipate that they'll have better budgets and the price of gas will recover and they'll have more money in the future? Also, well, you may say, okay, well, geez, they're going to put the pipeline in. That may expedite my royalties. Be real careful in that analysis, but maybe that's what you think. And again, let's look at then, okay, well, how long does the company have to decide whether they're going to use this agreement or not? And if that answer is 3, 4, or 5 years, my advice, specific advice now for everybody, think about it. Why am I doing this? Then if you decide that you're going to do it, you better get assistance. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. If you're going to enter into any contract, pipeline agreement, contract to sell your gas rights that I talked about earlier, I don't care what the contract is. If you're going to enter into a contract with a gas or pipeline company, I don't care if, I care. I hope it's me. It doesn't have to be, though. Get somebody. Get someone that knows what they're doing that can help you. Routinely, when a client calls me, routinely, we get more money and better terms and language. However, there are certainly times where landowner calls, says, hey, we do a review and consultation, and ultimately the landowner determines, hey, look, it's just not the time to move forward. I'm going to wait and see how this thing plays out. Now, that's entirely up to you, but you got to get information. And who are you going to use from your source as your source of information? I certainly hope that it's not the person sitting at your table who actually works for the other side, works for the pipeline company, works for the gas company. And please tell me and think about this. If you're relying on the person working for the gas or pipeline company, ask yourself why. Ask yourself why. Ask yourself if all the people that signed gas leases from 2005 through the beginning of 2008, if they regret relying on the statements and representations made by the person who worked for the company. Ask yourself that. And in many cases, ask yourself this. Hey, look, I signed bad agreements in the past. Do I want to fall into that same trap again? We got to make sure that you're looking at everything and you're protecting yourself. And I scream it, I say it, I repeat it, I do the radio show, I have the websites, all of these things. And, look, it's not changing everything, but we definitely know we got a lot of people that are signing a lot better agreements. And that's what we need to do across the board. We got to stop signing bad agreements and agreements that you do not understand fully and understand how they may impact you in the future. You're listening to All Things Marcellus with me, Attorney Doug Clark, and I am going to talk now about a specific pipeline agreement. Now, this is interesting because this is an old East pipeline right-of-way agreement, East Resources. So what's really interesting about this is this agreement was entered into by a landowner simultaneously to the time that they entered into their oil and gas lease. What is exceptionally disturbing to me in this case is the landowner who signed the oil and gas lease signed a gas lease that was extremely restrictive on pipeline rights, meaning that the only pipelines that could go into or onto the property that could be constructed on the property were those that were going to be carrying that landowner's gas, and that's it. No foreign, no third-party gas. Landowner also had input on, and fairly substantial, on the location of any proposed pipeline. They also, I believe in this case, had language in the agreement that said that no pipelines could be installed, say, within 500 feet of a residence, barns, septic, things like that. So they had a lot of restrictions there. Most importantly, they had the restriction that no foreign or third-party gas lines could be put in their property, and they had significant amount of input and control over where lines would be located. Well, I don't think, and I know in this case, this landowner had no idea that as they were signing all of these documents, they also were signing a right-of-way agreement for future pipelines. Now, look, that's what it's called. They understood they were signing it, but they didn't understand what all this stuff meant together. And that, my friends, is an enormous problem. When we get back from this next break, I'm going to explain why. And again, why it's so darn important that if you're going to put your signature on any piece of paper, you better darn well understand what you're signing, how long it's going to be in place, what are the good, what are the pros, what are the cons, what's good, what's bad. You better know. We're going to get into that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, I'm here with you every Sunday from 8 to 9 a.m., and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Going to jump again right back into it here in the fourth and final segment of today's show. Before I do, I want to remind everybody, you can go to pagasleaseattorney.com, pipelineattorney.com, pagasleaseattorney.com, pipelineattorney.com. Great landowner information available on both websites. It amazes me. If you listen to the show, I guarantee you, if you go to the websites, you're going to find them to be a very valuable landowner resource. Whether you're looking for representation or information, go check out pagasleaseattorney.com and pipelineattorney.com. Sign up for our newsletter. As with all our public information, it is completely free. If you don't like it, you can unsubscribe. If you like it, it comes about once a month, hot topics addressed, and you can check it out, and you can quit at any time. We do not send out a bunch of emails soliciting business and things like that. We want to get you, the landowner, good quality information. If we raise up everybody will do better. We want to make sure that we're getting the best information and education out there for you and for everybody. So check out pagasleaseattorney.com. check out pipelineattorney.com. We'll have today's show up on Monday morning. Monday morning, it'll be available, as we have, 50 or 100 hours of other radio shows. And what's really neat, they're up there by index, so you can find gas lease show, pipeline show, buying and selling gas rights shows. You can find any type of show up on the website, royalty shows, gas market conditions, what should you be doing, what should you be thinking about. You will be very hard-pressed to find or have a topic that there's not a radio show or even multiple radio shows addressing. So you can also search. Go to pagasleaseattorney.com, pipelineattorney.com. There's a search feature, and you can type in pipelines, gas lease, amendments and modifications. We got to get this big thing in Tioga. But, I talk a lot about Tioga recently because that's where there's so much going on, Tioga County. But it's still, same thing. I get clients all over the place. But Tioga County is the hottest spot in the state of Pennsylvania. And the reason is because they're looking, there's not the infrastructure, and they're out now trying to buy cheap pipeline right-of-way agreements, trying to use, in my opinion, landowner frustration to secure bad pipeline agreements, 10-year gas lease agreements, and here I go, breaking my rules, at 12.5% royalty, the lowest royalty that you can possibly be given in Pennsylvania. Oh, and by the way, if that's not enough, we're also going to take full and total deductions for everything and pay you the lowest possible royalty rate that we're allowed to in Pennsylvania. And oh yeah, one more thing. It's for 10 years. And these agreements, virtually all of them, offer no shut-in protection or very little, which means that, hey, after 10 years, you can end up seeing a permit being filed. I talk about this. You see a permit filed. Then they go and drill the well over the next year. Then they cap it and shut it in. And now you may see 4 or 5 or even more years before you ever see a dime. That is absolutely possible. Ask all the people, a bunch of people, not all, but ask all the people that are impacted right now in Tioga County that have these wells there that are capped and they're only receiving shut-in payments. They're not real happy, and they shouldn't be. They shouldn't be. So, all right, I got to get back to my pipelines, but I'm just telling you, check out the websites, get good information, think about these things. Commercial alert. I do these reviews and consultations, and I'm telling you, for an hour or two of time, you can become so much more educated and informed about your offer and decide if you want to continue. Or you say, hey, you know what? Now I understand things a lot differently, and maybe I don't want to continue. Or, hey, now I understand things a lot better, and you know what? I think this is the time. Or, yeah, I would go forward, but instead of 12.5%, the lowest possible royalty allowed in the state with full deductions, let me just counter and say, I'll take this and I'll move forward if I could have 15% maybe and eliminate or reduce post-production cost deductions. And again, I say it all the time. Look, if somebody's promising you that you will not have deductions taken from your royalty, my answer to that is don't believe them. And I say the same thing. I was talking about in a seminar recently. If I don't even tell people that. So if I told you that, I would be very skeptical of me telling you that, because I've seen cases where I thought, hey, there's no way a company's going to take deductions with this language. And sure enough, they do. So you have to be super careful. Again, be careful relying on the person sitting at your table telling you you're not going to have deductions from your royalties, because in a shocking surprise, many, many people have done that, and many, many, many thousands, and I'm not exaggerating, literally thousands of people have thought they would not have deductions and now have deductions from their royalties. And in many cases, and in most cases, they're very, very significant. So please make sure that you're getting the information before you sign any document. You are listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always contact my office, 570-307-0702, 570-307-0702. 0702. So, okay, I want to talk about this East Pipeline right-of-way agreement that I was saying before. The landowner entered into a pipeline right-of-way agreement simultaneously in the same day, within the same hour, within the same probably, within 5 minutes of each other, signed one document that had all of these restrictions on the pipeline rights in the gas lease, and simultaneously signed a pipeline right-of-way agreement which eliminated all of the restrictions that they had negotiated or worked for in the lease. When you sign a pipeline right-of-way agreement as a separate document, that document will control the installation and the rights that a company has to install pipelines. So if you have restrictions in your lease and you like those and you sign a separate pipeline right-of-way agreement, that lease isn't going to control with that company and that pipeline right-of-way agreement. They're going to look at the pipeline right-of-way agreement because that's the document that gives them pipeline rights. I can only conclude that people did not understand what they were doing when they signed both of these documents at the same time, or it simply makes no sense that they would sign both. There's no logical conclusion other than the landowner didn't understand and wasn't informed and signed both documents. Otherwise, they wouldn't have done it. So I got about 5 minutes. I want to blast through some important parts of this. So, okay, pipeline right-of-way agreement entered into with East Resources, same time as gas lease. Well, the pipeline right-of-way agreement allows the company to lay, maintain, remove gas pipe lines over across the premises. Goes on. Valves, drips, measuring equipment, other necessary appurtenances, along with the right to install, maintain, operate, and repair and remove and replace same. This pipeline agreement goes on to state that failure by the company to make use of this pipeline agreement within the primary term of the gas lease shall terminate the pipeline right-of-way agreement. Let me explain that. So, you as a landowner, in retrospect, looking back, probably made a mistake. You signed a very bad pipeline right-of-way agreement. But this pipeline right-of-way agreement says that once your lease terminates, your gas lease, which you signed at the same time, once it terminates, so does the pipeline right-of-way agreement. Well, lo and behold, this person and many others in Tioga County especially, same position, well, company comes and wants to extend your gas lease. Well, by extending your gas lease, you're also extending this horrible pipeline right-of-way agreement. If for some reason you want to extend your gas lease at this time, one thing that you could probably do, if you just know to ask, is get rid of and terminate this pipeline right-of-way agreement because it's a bad deal for you. So if, I stress if, you want to move forward with the lease, you extend the lease, you also extend the pipeline right-of-way agreement. If you're going to extend the lease, get rid of the pipeline right-of-way agreement. It's a bad agreement. It goes on and states that the payments are going to be made, they're going to be just these reasonable damage payments. There's no price per foot set forth in here. And look, I'm going to be brief here. There's ingress and egress, entering anywhere over your property to get to the pipeline right-of-way agreement. Oh, and allows for the installation of additional pipelines in the future. And I don't see anything in here about where the pipeline is going to be located, so you have no input on location. So you can put as many pipelines as they want, wherever they want. They have to pay you reasonable damages to crops, fences, buildings, drain tile, things of that nature. And then it goes on. They have the ability to, from time to time, lay additional pipelines alongside of or connect with. Well, that seems like maybe that would be perpendicular, meaning that you may have pipelines that are in more than one. You don't have just a single easement running across your property. You may have multiple easements going in different directions. Not real clear here. So it goes on to say they can change the size. They can also change the size of the pipeline, install new ones, dig up time and time again. No limitations whatsoever. Oh, and by the way, there's no liability protection here. So if there's a problem, you're going to get sued. There's no time frames other than that they would have to use the agreement within the primary term of the lease. Well, your ticket is, you have a ticket out here because the company is asking you to extend the primary term of your gas lease. If you don't, the gas lease terminates, so does the pipeline agreement. If you do extend the gas lease, you also extend a terrible pipeline right-of-way agreement. I wonder if this is something that's being discussed with you at your kitchen table. I can tell you with this gentleman, who we've dealt with all of these issues already, it wasn't discussed. Nobody pointed these things out to them that, hey, by extending this, you're also going to extend this terrible agreement. But if you know to ask, if you say, well, I'll extend my pipeline right away, or I'll extend my gas lease, but I want to get rid of this bad pipeline right-of-way agreement, I think you'll find that the company will be more than happy, even though they love the pipeline right-of-way agreement, they'll be more than happy to extend a bad lease at very low compensation levels. They'll trade a bad pipeline agreement to extend a bad lease at bad compensation levels. So be careful. Please be careful. Again, in this agreement, there's no liability. There's no restrictions on a number of pipelines. There's no location input or location identification. We don't know how many of these pipelines there can be. There's no reclamation language of any significance. Nothing on clean and green. Nothing really limiting on roadways. And there's one more crazy thing I want to say. So in this particular agreement, this gentleman had multiple parcels, say, and say you had, pick a number, 3 parcels. And what happens is that one of the parcels ends up having development by the end of the term of the lease. And when I say development, it could be just as unitized. So if you have all 3 parcels on the same lease, and any acre of any of the 3 parcels, whether they're contiguous, whether they're in different counties, whether they're in different townships, doesn't matter. If 1 acre or even less than that is unitized and you don't have Pew clause language, all parcels are held. One reason why we want to keep them in separate leases. So if you entered into a pipeline agreement that's tied to the length of time that your gas lease exists, well, be careful, because that pipeline agreement could end up lasting for a very long time as a result of the fact that maybe 1 acre or less, or maybe more, of one of your parcels was unitized by the end of the primary term. Do not sign pipeline agreements with your oil and gas lease. To the contrary, reduce pipeline rights in the gas lease to protect yourself in the future, and reserve the right to negotiate or decline future pipeline agreements. That is the way to handle it. You've been listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me every Sunday from 8 to 9 a.m. on this station, and I'll be, I won't. I'll be back next week. Have a great week, everyone. Oh, and the landman works for the company, not you, the landowner. Have a great day.